And joining me now is Congressman Jamie Raskin, a former member of the January 6th Select Committee, and we always like to point out a constitutional scholar in his own right. So, Congressman, I mean, in watching it myself, it felt to me like the justices collectively had already kind of concluded that they want to keep Trump on the ballot, and this was a search for the rationale as to why. Did it feel that way to you?
Yeah, I think a majority of them certainly came in with their minds totally made up, although a lot of them are seeking to hang their hat on a different hook. Some of them like the idea that the president isn't even covered by Section 3 of the 14th Amendment, which I think the vast majority of the justices reject. Others were congregating around this argument that you were just discussing, that under Section 3 of the 14th Amendment, Congress needs to act and the states don't have the power themselves to enforce the Constitution, which is a somewhat weird doctrine because under the Supremacy Clause, the Constitution governs every part of our governmental system. The federal courts, the state courts, the federal Congress, the state legislatures, and so on. And nonetheless, they are going back to this Justice Chase opinion in the Griffin decision. And I shouldn't really say Justice Chase, which is what the Supreme Court justices were saying today, because he wasn't acting as a Supreme Court justice. He was acting as what we would call a circuit court judge. He just rendered a decision on his own, which totally contradicted the position he had taken just a year earlier in the Jefferson Davis treason trial. And there he was advancing the opinion that why doesn't Jefferson Davis try to get off by saying he can't be prosecuted and convicted for treason because it would constitute double jeopardy because he's already been excluded from serving as president by Section 3 of the 14th Amendment. As a legal argument, that's totally wrong, of course, because Section 3 of the 14th Amendment is a civil disqualification, which can be removed by Congress ultimately. It's not criminal, so there's no double jeopardy, and that was perfectly clear according to the framers of the Constitution. In any event, all of it is irrelevant because it's not a binding Supreme Court opinion. So really, they're looking at it afresh, and a lot of them seem to like the argument that Congress needs to act. It was only at the very end of the oral arguments today that people began to focus on what the practical implications of that are. It basically means that they're going to let somebody go forward on the ballot who may indeed be or may likely be an insurrectionist who participated in insurrection, let it go all the way through the various states and get back to, yes, January 6th, in this case, 2025. And at that point, if God forbid, 1,000 times, Donald Trump were to be winning by 1 or 2 electoral college votes, it would be up to the new Congress to decide whether or not he was an insurrectionist barred from holding office rather than running from office, which is what their point is. And if you want to talk about a testy, potentially violent and explosive encounter on the floor of the House of Representatives, the Supreme Court is basically choreographing it.
Right. And for the audience to understand what that means, that would mean Mike Johnson, whose majority whip can't count enough for them to pull off the impeachment of Secretary Mayorkas, even though they desperately want to do that. That guy, who's barely hanging on to his speakership, that House of Representatives would have to decide. I mean, let's go through some of these, because some of them made no sense. There was the question of the self-executing part, meaning, to your point, what they're saying is somebody who didn't meet the age qualification, for instance, could run. They just couldn't serve unless it was remedied by the time they become president. He was making that argument. Well, they might become of age by the time they actually hold the office, or somebody who didn't live in the state. Well, they didn't live in the state, but then they move there. And then when they hold the office, then they're qualified. In the case of an insurrection, though, you know, this is somebody who actually attempted to halt the peaceful transfer of power. They would get to go all the way through the process of having enough electoral college votes. And then on January 6th, they would have to get a waiver from Congress that says, it's all right, man, you can go ahead and be president, right? That's what you're explaining. And
that's right. And it was galling indeed to see Justice Kavanaugh trying to invoke democracy as a value on the side of Donald Trump when Donald Trump and his followers tried to overthrow our constitutional democracy on January 6th. Section 3 of the 14th Amendment is all about protecting democracy against those who have proven their propensity to use violence and backroom machinations to try to overthrow the constitutional order, which is precisely what happened on January 6th. But just to understand how tortured their argument was, at least as I see it, the Trump's lawyers weren't saying that Trump can't be barred from holding office. They were just saying he can't be barred from running for office. Why? Because the Congress might be able to use its authority by a 2/3 vote to remove the disqualification for him being an insurrectionist. Now, as a practical matter, that will never happen. I can guarantee you, you are not going to have any Democrats, much less 75 or 100 Democrats voting to remove that disqualification. But as a legal matter, it's a clever argument, and I was impressed that they were making it. It does show how desperate they are, that that's what it's down to. But as a legal argument, I think you can match that hypothetical with another hypothetical, which is if hypothetically Congress were to remove the 2/3 disqualification after Trump has been barred from the ballot in Colorado, nonetheless, the Colorado legislature could then appoint the electors for him. So I would meet their extravagant hypothetical with another hypothetical, which is the Colorado legislature could go ahead and appoint him the electors that would vote for him, or indeed the Electoral College itself could use their reflective, deliberative capacity just to choose him as the president. So, you know, there's a lot of complications because of the Electoral College, but the bottom line is the Supreme Court has always looked at the electoral system as a practical matter. And as a practical matter, Colorado has been doing the right thing, but this court clearly doesn't want to do the right thing, and so they're going to throw it back to Congress. Nothing is going to happen until potentially January 6th, unless Donald Trump is convicted on some of the 91 federal criminal offenses that are outstanding against him in court.
Relinquish what remains of the Allspark.
So who's the insect? You? What? Who's the insect?
Protect you. They will defeat it on our world, and we will defeat them here.
This was just a diversion. Security, please bring up. Rabbit, she's already inside. Deeds! Give me an update on that reserve. What's readiness? What was his name? What was it?
Evac, sir.
Evac.
She's right in front.
We are facing a heavy, sustained attack. They appear to be after the Allspark. General! General! Evac immediately. Evac.